Good morning. Welcome to Legal Access, brought to you by the McGuire Law Firm. Today's topic is always a popular topic, so if you wait till the very end of the show to try to get in, you might not make it. So call now if you have any questions about wills, trust, and estates, something that everybody needs to know about and something that everybody wants to know about. So again, phone number is on your screen. Call us at 848-8080. We'll get you on the air and on the panel to answer those questions for you today. First of all, from the McGuire Law Firm is Ian McGuire.
Good to see you, Dave.
Also want to welcome back to Caitlin Floyd.
Hey, everyone.
And down at the left end of the table there, you got Margaret Evans. Hi, Margaret.
Good morning.
Last time you were here a couple of weeks ago, we got cut short because we had some severe weather. I don't think we have to worry about that today, so thanks for coming back.
Absolutely.
And as you said, Dave, this is always a popular topic, so it's great to have Margaret and Caitlin with us today. Caitlin, if you could start telling us a little about your firm, where you work, and what your firm does.
I'm at Rivertown Law, and we do family, real estate, estate planning, probate, and we are happy to help anyone that we can.
Good. And I know you're with a good firm. You're with, and it's Brad Smith.
Yes.
Yeah. And Margaret, tell us a little about your firm.
I'm with McCutcheon, Vaught, Getty, and Hux. We have two offices that are fully staffed at all times, Myrtle Beach and North Myrtle Beach. Now, I handle bankruptcy, family law, wills, and estates for the firm, but we do more. We handle personal injury, we handle real estate, criminal defense, and certain types of civil litigation as well.
So glad to have you back with us. You're with a great firm as well. And ladies and gentlemen, if you have any calls, call us 843-848-8080. That's 843-848-8080. You've heard what these attorneys do as outside of trusts and estates, and if you have any questions in that realm, you can feel free to give us a call on family court or whatever it is that you have questions about, and we'll do our best to answer those questions for you.
Always the first question that we usually get whenever we have this topic, ladies, is that, okay, I had my will done back in Pennsylvania or Ohio where I lived before I moved down here. Is it still valid in South Carolina?
So, yes, it is still valid in South Carolina as long as it was valid where it was created. I always recommend having it looked over just to make sure, you have everything that you want on it, everything is where it needs to be, and then you can go from there if you want to get it redone.
I would agree.
So let's just pick a state, if you're in Nebraska or Pennsylvania and you move here, is it a good idea just to redo your will at that point, or is it just make sure that the will was done properly?
Well, you want to make sure that your will is in compliance, first of all, and more importantly, does it meet the needs that you have currently? A lot of folks come to us that had their wills done maybe 15, 20 years ago when they had younger children who were minors. Now all those children are grown, they've left the nest, and maybe their estate planning needs have changed. And we can address that and get their documents not only in compliance with South Carolina law, but address any of their estate planning changes that may have occurred over the last decade or so.
And why is a will? I remember, obviously a lawyer, and I was had kids, and it wasn't until I was going away somewhere with my wife, and I was like, we need a will. What if something happened? But why is a will so important, and why even for younger people should a will be at least looked into doing early on?
Well, a will is extremely important because it directs the distribution of your assets upon death. If you don't have a will, then the South Carolina Probate Code, the portion regarding intestate succession, will govern how your assets are distributed. There's a lot of disadvantages to intestate succession, such as you have to get orders from the probate court to sell any personal property that's worth $10,000 or more. Most cars now are worth more than $10,000. You'll need to get an order from the probate court authorizing the PR to sell any real estate that the decedent may own. It also, like I said, it may devise it in a way that you don't want it to go. For example, if you die with a surviving spouse, that surviving spouse is going to get half, and the kids will share the other half. That could be a problem depending on how the real estate is titled in the name of the decedent and the spouse. she may be forced, if the husband dies first, for example, the wife may be forced to sell the home because the kids want it to be sold. Whereas you can direct how you want that to pass in your will, which will avoid a lot of those family fights.
The phone lines are open if you have any questions about wills, trust, and estates. Let's go to the phones right now. We have John in Myrtle Beach with a question. Hi, John. Thanks for calling in today. What's your question for the panel?
Thank you for taking my call.
Sure.
I wanted to know, now that I'm a widow, should I have my car and house now in trust to my 2 daughters?
Did you hear that?
Yes.
Yeah.
You don't necessarily have to have it in a trust. You can direct how you want it to pass from the will. You can do a deed deeming it joint rights of survivorship. There are many different options. Anything else, Margaret?
I would suggest that if you already have a trust, you may want to update the beneficiaries of your trust, things of that nature. You may want to consider having your bank accounts, having a payable on death beneficiary named on your accounts, your bank accounts. It depends on if your estate planning needs have changed. If a will do it, if the current estate planning documents you have will help affect your wishes, then there's no need to change. But I would recommend that you have a lawyer take a look at it and review it for you and talk to you about your particular needs and what you're hoping to have happen to your assets upon your death.
Along those same lines, before we run to a break, a lot of people will call up and say, hey, I want to pass my house to my children or something like that. Should I put my children on my deed or on the title as well, or should I just do it through a will or trust or probate?
There are 2 reasons you should not put your children on the title to your home, your adult children. Their creditors can become your creditors. I've dealt with that issue on the downside of it with a bankruptcy matter. And there are other issues. First of all, their creditors can become your creditors if they have tax liens, judgments, anything of that nature. Those liens are going to attach to that real estate whether they're yours or not. If their name is on it as a joint owner, that's a problem. The second problem is the tax issue. They will receive as a tax basis the stepped up basis or the fair market value of that house at the date of the decedent's death. Whereas if you put them on title while you're still alive, they're going to get whatever adjusted tax basis you have in that property. So those are the 2 main reasons I always tell folks, avoid putting your grown children on your deed. They're better off inheriting it through a will or a trust.
Absolutely. All right, our phone lines are open. We do have somebody else on hold right now, but we got to run to a break. As soon as we get back, we'll answer that call and all the rest of your calls as well. If you have any questions about wills, trust, and estates, today's the day to get those questions answered right here on Legal Access, brought to you by the McGuire Law Firm. Our topic today is wills, trust, and estates, something that everybody has questions about. And if you do, today is the day to get those questions answered. Give us a call. The phone number is 843-848-8080. There it is right there on your screen. Katie's been very patient, holding on the line during that break. Katie's in Myrtle Beach. Hi, thanks for hanging on, Katie. What's your question?
Yes, my question is that I am now 75 in April, 26 to be exact, but I have last summer made will. I have 3 properties, 1 in Berkeley and 2 in Myrtle Beach. And something came up in our Easter dinner conversation is that in the will I had assigned the houses to be sold to my kids. But what I don't want them to go through is to pay taxes. And so should I go back to the attorney that made the will and kind of rewrite that my kids don't pay any taxes on these properties?
So you're saying if you've left one of the property to each of your children? It's just so we're clear.
No, they're really not. No, they haven't been given to them as of yet. But all three properties are under my name,
Right.
and so I don't want them to pay taxes once I die. So, is there? Someone mentioned that maybe I should gift the houses so they don't pay taxes. So I'm not sure what to do.
No, so is that more a question for a tax attorney? But I know that, so would they pay like a state tax on what was left to them?
We don't have inheritance tax in the
Okay.
state of South Carolina. Whether or not a beneficiary is going to be responsible for inheritance taxes is going to depend on what state they reside in. For example, I know Pennsylvania still has an inheritance tax, but South Carolina does not. What she's asking has a lot more layers of that onion that need to be peeled back, so that would require a consultation and a much deeper, more in-depth discussion than we have time for here today.
Absolutely. Katie, you might want to try to get in touch with an attorney and talk to him a little bit more in depth, as Margaret said. If you have any other questions, give us a call. The phone lines are open. The number is on your screen right there. All right. We were inundated with a lot of commercials about wills on the internet and on TV right now. What's the disadvantage of doing one of those internet wills that you don't get from going to one of you two ladies?
I don't feel like they can always be statutorily compliant. They are made for, like it's a Google will, so it's going to be generic. It's not going to be state specific. We don't know if it's going to cover everything we need it to cover. We don't know if it's going to hit on everything that the state requires it to hit on, covering personal representative, bond, or burial instructions.
Well, one of the issues with the online wills, they won't usually determine whether it's a per Stirpes distribution or a per capita distribution.
I'm going to stop you because people are going to go, what's per Stirpe, what's per capita? So
Per Stirpes means if you have 3 children and one of them predeceases you, a per Stirpes distribution would split it up between your 2 kids, and the deceased child's children would get that share.
Gotcha.
That's a per Stirpes distribution. Per capita means whoever's left alive. They don't talk about that. Maybe
and that's a big deal.
That's a very big deal.
Yeah.
And we need to deal with minors. Minor children can't take by law, but we can set things up in a trust for them. We can set up specific uses for that money that the trustee can allow, such as educational expenses. Maybe you have a special needs beneficiary that can't actually get the money, but we can set up a comfort care trust for them called a special needs trust, and you can embed those testamentary trusts in a will for them.
If you set somebody up with the power of attorney for yourself, they basically have the power to do, I mean, you need to make sure and vet them ahead of time so they don't rob you blind, because once you've signed that, they've got, say so over all of your assets, right?
Well, I've dealt with that before, and if they are not, if they find that the person they've deemed as their agent or listed as their agent, then we have to file what's called a revocation of POA. And a lot of times we're going to have to deal with the financial institutions that the agent, the bad guy, has gone to and tried to usurp their authority and get funds from the principal. But yeah, it's a very dangerous document. It's a very wonderful document, but it can be dangerous. You need to make sure you trust folks implicitly when you assign them to be your agent under a general durable power of attorney. I mean, I tell people, think about who you would trust to hand your checkbook to.
Right.
That list is probably going to be pretty short with most folks. It should be.
The other end of that, if you were the person that was given that responsibility, you still have not only ethical but legal responsibilities to use that money only for the benefit of the person you represent. Is that right?
That is true. Yeah, agents do have a fiduciary responsibility to act in the best interest of the principal only, and they can be held liable in a probate court proceeding if they choose not to.
So, Caitlin, just because somebody has a unlimited, unfettered ability to do, they could get in trouble criminally, right? As well, if they use if they
Yes.
reach that fiduciary duty?
Yeah,
They can.
yeah.
Okay.
Phone numbers on your screen. If you have any questions about wills, trust, and estates, today is the day to get those questions answered. Let's go to Myrtle Beach again. Ron is on the line. Hi, Ron. Thanks for calling in. What's your question for the panel today?
Thank you for putting this on.
Sure.
Me and my wife both are 70, and we own 2 houses, one in North Carolina on the family farm and a house here in Myrtle Beach. And right now we just have a simple will passing these properties to our children. And I was just wondering, would a trust be a better way of transferring these kinds of assets? What would be the advantages and disadvantages of doing that?
I would suggest that if you have multiple properties in multiple states, a trust can make that process much easier, but it can still be done with a will. We should probably have a more in-depth discussion about your particular needs, your estate value, the gross estate value we anticipate at the time of your death, any issues involving your children. It's a multi-layered question with a lot of issues that we need to talk about, ancillary issues we need to discuss. I'd hesitate to give you a general answer. Unfortunately, like most things in the law, there is no simple, easy answer.
And you'll also have to have an estate open, more than likely in South Carolina and North Carolina, to deal with and to address both properties and the ownership of them.
Right.
Correct.
All right, Ron, hopefully that helps out. We appreciate you calling. If you have anybody else out there has any other questions, going to run to a break right now, but we'll be back and be happy to talk to you. Our panel is waiting for your questions to go ahead and give you answers. Ian McGuire, also Caitlin Floyd, and Margaret Evans. Call us at 843-848-8080. We'll get you on the air right after this break right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. Wills, Trust, and Estates. That's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Our phone lines are open if you have any last-minute questions. Got a little bit less than 10 minutes to get you on the air, but that's still plenty of time to get your questions answered. All right. We talked about that. All right. What kind of life events, if you've had your will done like you talked about 10, 15, 20 years ago, what kind of life events, if they've happened to you, would probably trigger you wanting to get a will redone?
Marriage, divorce, birth of children. If you are married, whenever you have a will created and then you subsequently get a divorce, it's as though your spouse named in your initial will predeceases you. So that's a reason to get it done as well.
Well, having done some divorce work as well, I always advise my clients, we need to talk about estate planning once this divorce is finalized, because you probably have your spouse named as a beneficiary on life insurance policies, things like that. So it's a good time to look at everything after a divorce or those major life-changing events.
But once a divorce is finalized, your spouse is completely cut. You don't have to, even if you die before you redo your will, your spouse is not going to be getting your inheritance.
In what they're left in the will, no, but on 401ks, life insurance, anything like that, the spouse will still be entitled to.
Yep. Mm-hmm.
All right, what if somebody's been named the executor or the personal representative in a will, but it comes down on them, they're like, hey, this is too much work for me, I really don't want to do it. What happens at that point?
They can always renounce their right to be the PR and let it go to somebody else who's named as a alternate PR under the will. But all the beneficiaries are going to have to sign that they're okay with that and consent to that.
All right, a couple minutes left in the show. Let's go back to the phones. Grace is in Myrtle Beach. Hi, Grace. Thanks for calling in right under the wire here. What's your question for the panel?
Question is, can you talk a little bit about irrevocable trust?
An irrevocable trust?
Yes.
In what capacity and how? You just want to learn a little more about what it is?
Yes.
Okay. You want to talk a little about what an irrevocable trust is?
Okay. Most clients end up doing revocable trusts. And a revocable trust allows the parties to make any changes to the trust beneficiaries, to the trustees, whatever they want to do. But a trust is a nice vehicle to have because you avoid the probate process, provided, however, that you have adequately funded the trust. Sometimes people will come in wanting to probate an estate or talk about somebody who's died and they've got an online trust. Well, you have to title the vehicles in the name of the trust. You have to put the real estate in the name of the trust. If you want to control the use of a particular life insurance policy, the proceeds, you need to make the primary beneficiary the trust. And there's a lot of moving parts to a trust. They're wonderful, and you can avoid probate. And they've got more flexibility.
I didn't mean to interrupt you, I guess I did, but like the big advantage to it is that you avoid probate?
You're avoiding probate,
Okay.
correct.
For the most part, there's always something that comes up.
Yep.
So it sounds like a great idea, but inevitably there might be something, but it might streamline things a great deal. Is that fair?
Yes.
Yeah.
It does, and it also takes away that waiting period. There's a creditor's claim period that is mandatory. It's under our probate code, and that requires the estate to sit stagnant and not do anything until the creditor's claim period has run.
Okay.
All right, you see in TV shows and movies where they found a handwritten will that grandpa left before he died. In South Carolina, that's not legal, is it?
It depends. Was it notarized? Was it witnessed correctly? Did it comply with our statutory requirements? And then it's still going to be up to the judge's discretion to make that decision.
That would be a holographic will, and sometimes, it depends. That's another reason to go to a lawyer and spend the money to have it done so that you're not wasting a lot of fees in probate court in a fight. And I've had some of those fights recently. And another thing people do is make handwritten changes on their will. You cannot do that.
Right.
The changes must be executed with the same formality as the will itself. Yep.
All right, we've got about 2 minutes left in the show. Randy is on the line here from Myrtle Beach. Randy, very quickly, what's your question for our panel here today?
Okay, quickly. I became a legal guardian of my girlfriend's grandson. That she's been living with me for over like 30 years, and we tried to get a passport for him, but the legal guardianship paid signed by a judge. Is it still legal or not? Because we've been using it for he's going to be 18 in a couple of months.
It's more a guardianship question than a will, trust, or estate, but is that something y'all can answer?
It was.
Well, that's going to depend on, do you have guardianship through the family court? Is there a custody order that allows you to act as his parenting parties?
So far, yes. So far, I have been, but the only one that didn't accept the paper, the guardianship paper, was when he tried to get a passport, and they denied it because a judge did not have a seal on the paper. So I don't know if I'm really a guardian of his or not.
All right, Randy, we'll see if we can answer that in a couple of seconds. Is that something you need more information on?
Yeah, we're going to need a lot more information from you regarding the minor child and review the paperwork that you have before we can fully answer that question for you.
Yeah, sorry I can't give you more of an answer on that, Randy, but we do appreciate your phone call and appreciate you watching here today. So we've been talking about wills, trusts, and estates. Thanks to our panel here today, Ian McGuire, Caitlin Floyd, Margaret Evans. Thanks for being here. I'm Dave Priest. When we get back next week, we're going to be talking about real estate law. If you have any real estate questions, next week's the week to get those answered right here on Legal Access, being brought to you by the McGuire Law Firm.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to